get asked a lot of questions about joint tenancy because joint tenancy is probably one of the most overused and misunderstood tools in estate planning. So let's just back up and talk a little bit about what joint tenancy means. When you own a piece of property, for example, a piece of real estate, right? You could own it with another person either in joint tenancy or as tenants in common. So, joint tenancy, two people own a piece of property together. If one person dies, their interest immediately transfers over to this other owner, as opposed to tenancy in common. With tenancy in common, if you have two owners and one owner dies, it's like that person's 50% of the estate now transfers down to their heirs. And the way that it gets there is by going through probate, right? So remember, joint tenancy immediately transfers to the other joint owner. Tenancy in common will trigger a probate to transfer the interest down to the heirs. Now, the heir might be this other person, especially if it's spouses. So one of the first and most important things to remember about joint tenancy is the way that you determine if a property is held in joint tenancy is by looking at the deed. The deed has to say the magic words. It has to say that that property is titled in joint tenancy or as joint tenants, or even JTWROS, which stands for Joint Tenants with Rights of Survivorship. If the deed doesn't say those words, then the property is actually held as tenants in common. Now that's a Colorado rule, okay? I do encourage everybody to just double check their deeds because most people assume that their property is held in joint tenancy and don't realize that it may be held as tenants in common. And that's always hard because then that means we have to probate half of a house, right? If a husband and wife own that property together and one of the spouses dies, then we would have to probate half of the house just to get that interest to the other person. And that's an expensive and long process. Now the problem with joint tenancy is that a lot of times people will hear, if you want to avoid probate, then put the property in joint tenancy, which actually can work, right? But there's other problems that come along with it. So let's say that you have a parent who wants to avoid probate, so they decide to add their children onto the title of their property as a joint owner. Sounds like it'd be easy. When the parent dies, their interest would then just transfer to the other joint owners, right? But here's the problem. When you add somebody onto the title of your property as a joint owner, somebody who's not your spouse, you're actually making a gift to them of an interest in that property. So first, you should be filing a gift tax return. But second, when you make that gift to that other person, it's not just for the consequence of how the property transfers at death, it's actually putting them on title now, so they own that property right now. So think about this. If I add my 25-year-old son, who might not be very responsible, onto the title of my property, and then he gets into a car accident and he gets sued, is his creditor, his judgment creditor, going to say that they don't want to collect from his interest in my house? Probably not. And the same thing goes if he gets himself in trouble with credit cards or debt or tax problems. That could impact my ownership on the property. And what if he gets divorced, right? Divorces are always super friendly and everybody plays nice. So it's his future ex-spouse going to not try to file a claim against his interest in my house? I don't think I want to find out. The other problem is taxes. When you add someone onto the title of your property, when you make that gift to them, they take that gift at the original owner's basis, which means that when that person goes to sell the property, their capital gain is the difference in value between what the original owner paid for it, plus improvements, and what they sell it for. As opposed to if that person, the original owner, had kept the property in their own name, then at death, the property would get a step up in basis, meaning that the basis is no longer what they paid for it plus improvements, but now it's the value on the date of death. Which means that if you bought that property in 1960 for $10,000 and now it's worth $500,000, you want that step up in basis so that your family doesn't have to pay capital gains tax. But if you add your kids onto the title of the property, they lose that step up in basis, and now what they would pay in capital gains tax, most likely more than a probate would have cost. So it's important for each person to get advice specifically for their situation. There are other ways that can be used to avoid probate, and maybe in one of the upcoming talks we'll talk a little bit about beneficiary deeds. Thanks.